maybe we'll get into reports at this point, because the Toyon dispensary general plan amendment zone change parcel map AUP what has been appealed, and it will be heard on the 26th of May of April
To the board?
to the board. I think that will set some policy direction for us. We've got 2 other applications that are pending, and had originally planned to have those scheduled for the 28th, but thought we'd wait and see what the board says about that application, because that could change our recommendation based on board policy. So we plan to bring those to you on the 12th.
May 12th?
May 12th.
Okay.
You say there's going to be 2 applications.
They're both from-
Zone change in AUP.
I'll be here.
Okay.
I guess that's really all I have. Unless,
All right.
we want to talk about what the board did on medical cannabis on Tuesday.
Well, maybe we should have the, I don't know.
Public comment first?
Yeah,
Do
I
we
don't
want
know.
to take a motion on the safety element as
Oh.
amended?
Sure,
Thank you.
all right. So is there a motion
Not
to,
safety element, I'm sorry.
yeah, the
Public facility.
yes, public facilities.
Yes, I'll make your motion for the safety element.
No, public facilities.
Public facilities.
And
the
we're
motion-
moving recommendation
The
to the
move
Board
is-
of
yeah, the
Supervisors.
motion is to
Yeah,
approve the changes made today and for those edits to the Board of Supervisors.
right.
Seconded.
It's been moved and seconded, all in favor?
Aye.
Okay, we're moving ahead.
Great. Thanks.
So let's have the public comment period, and then there'll be reports, and then we'll be done. Anybody in the public want to address the planning commission? All right, good. Not good, but thank you. On to reports.
So the only thing I'd like to report on is the board's hearing on Tuesday on the urgency ordinance on medical cannabis. The board took no action. It would require a 4/5 vote, and there wasn't a majority, 4 members that could agree on what direction they wanted to go on that. It was a long hearing. We started at 11 and we didn't end until after 6. The intent was to try to freeze where, to sort of allow those that have been given tacit approval previously to continue their operation and continue growing, but sort of freeze things so we wouldn't, authorize any new. And we're not really officially authorizing anything. We're going to register those, but no new cultivation. There was opposition sort of as far as the ordinance goes on both sides of the aisle. Those that felt the ordinance was too restrictive, they wanted to have more allowance for people that either lost their homes in the fire and moved, or new people that acquired property and had already begun or were in the process of acquiring property. The other side was we don't want it and it should be banned, and don't even allow it at all. And lots of in-betweens of that. So between all that, the board just said we're not ready to adopt any urgency ordinance and to proceed with the direction we gave you previously, and so we're working on that. The request for proposals for the EIR, and we'll be preparing an EIR on that ordinance. There's enough controversy, enough issues that we felt that it was appropriate to prepare an environmental impact report on the provisions of that ordinance. That proposal period ends next Friday, so we'll be having proposals from consultants. We're going to move as quickly as we can on getting them on board and getting the process going. We actually have already filed the notice of preparation so that we can get public comments on what issues should be addressed in the EIR. So hopefully,
Is there an ordinance that exists for them to
There
do
is
an
a-
EIR?
there is a draft ordinance based on the board's direction from February 16th. It's posted on our website. And
I didn't think they voted on anything. I thought that was just a meeting to
well,
give direction.
it's the direction, and it is the draft based on what we understand the board's direction to be. So it is a draft ordinance. It could change. It's not been adopted. It's just that this is the ordinance that the board saw with the changes they gave direction on the 16th.
And did the board vote to move forward with the EIR?
It's not the board's decision.
Okay.
It's staff decision on what's the appropriate document, and we've worked with county council and looked at what has happened in other counties And we feel that's the appropriate action to take.
And how much does that EIR cost?
We don't know yet. Our intent is to establish a fee that those benefiting from those regulations will reimburse the county for the cost of that EIR.
And in your previous comments, you said that to allow the people that we have given approvals to operate already. We've given approvals?
Tacit approval. We have not authorized anything, and in fact, technically, it is not authorized. We have what's called a permissive zoning, and if it's not listed in our zoning ordinance, it's not allowed. Code is silent on cultivation of marijuana. We treat marijuana differently than we do other agricultural crops. And so, we've had arguments that, well, it's just like any other agricultural crop. So if you can grow tomatoes, you should be able to grow marijuana. We don't treat it that way. We treat it differently. And so technically, under our code, it is not permitted. The board has chosen not to direct code enforcement or the sheriff to do an active enforcement on cultivation, other than clearly those that are associated with other illegal activities, and the sheriff's office is doing what they can to remove that aspect. But so we will continue to develop the ordinance based on the board's direction. In the meantime, when people come to our office and ask, where can I grow? We say, technically, you can't. There is no ordinance that allows cultivation in this county right now.
You say you want to continue to work on the ordinance as directed by the board.
Yes.
The direction from the board on Tuesday was
Moratorium.
what?
They took no action. So we go back to the February 16th.
But there was direction.
Well, the
There was this, there
direction in
was,
February. At the workshop in February, the board says, this is what we want to see in the ordinance.
Okay.
That's what we're working on.
did you not hear something different on Tuesday?
Well, they
No.
needed 4 votes, so no.
No action was taken on Tuesday.
No action was taken, but no action was taken on February 16th either.
No, there was action. There was direction given by the board. They had a series of motions. We want this, we don't want that.
Including like dispensaries will still be limited to CP,
Oh, I
kind of.
Yeah.
didn't think those were
But the-
actions. I thought they
Well,
were.
they didn't adopt an ordinance.
But
They told us to write an ordinance that has these provisions in it.
Okay.
And that's what we're working on right now. We have the draft ordinance. The next step in the process is to look at the environmental effects of that ordinance.
But wait a second, Peter. There was an action taken Tuesday. They voted no on the urgency
Right,
ordinance. Okay.
yeah.
And in voting no on it, they also made comments as to why they voted no on it. At least 3 of them did.
Yes.
And the consensus of the 3 was that they were, it sounded to me like they wanted to move in a different direction. Now, my concern is that if you're going ahead with an EIR that's based upon more or less the provisions of the urgency ordinance, that was voted down.
No, there was the draft urgency ordinance and then the proposed permanent ordinance. 2 separate things. They were very similar in some ways.
Yes.
But they were different in other ways. And the main difference was we were creating a registration process that said we're going to recognize these growers that were here previously and put a halt to anything else.
That was voted down.
That was voted down.
Right.
So we go back then to the status quo of the board's direction on the 16th to prepare a permanent ordinance. Now, I know there were 3 members that said, at this point in time, I'm willing to just put a ban on it, temporary ban. But that in and of itself required a 4/5 vote to pass.
Okay.
They
But,
didn't propose that. They didn't propose to amend to adopt an ordinance to do that.
okay. But didn't that action trigger a
Are we
new
getting into a
route?
discussion about something that we haven't agendized?
We're talking,
Well,
I'm just wondering.
Yeah, I don't think so.
I mean, it's getting pretty,
Yeah.
I mean, we might be skirting it, I'm just saying.
I'm talking procedures, not,
Yeah, I don't think we're actually, I mean, it's just a report of what happened on Tuesday
I'm
and
not
how
talking
it
about
affects
merits
us.
here, I'm just talking
Yeah.
about
No,
procedures.
but he's getting at intent, what was the intent of the board, and what were they thinking? And
Because
does it match what their previous discussions? I don't know,
Be-
I'm feeling like we're,
Because I got from Peter what triggers the move toward an EIR. And that's...
The direction by the
it's the
board on
same
February
discussion.
16th to
Okay.
prepare, and they did not take any other, and they did not pass another motion to change that direction.
Okay. Procedurally now, we are going to get an ordinance.
Yes,
We are going to pass something along to the board for consideration.
that's correct.
And that, what would be the time frame for this to happen at the earliest possible time frame?
Probably next fall, this fall. To prepare the EIR is going to take us at least,
No, I'm talking about an ordinance.
before you can consider the ordinance, we have to complete the environmental review.
Before we consider any ordinance or one
Sure.
particular kind of ordinance?
Any ordinance. So we have a project description, which is a draft ordinance based on the board's direction. The EIR consultant will look at the potential impacts of that. We will consider alternatives in that EIR and look at what, comparatively the impact of an alternative might be. And then you as a body will then review that using the EIR as information to help assist you in determining what's your best recommendation to the board.
Okay. Procedurally, can this body initiate an action for consideration by the board?
Such as?
I mean, you could make an advisory.
Everything we
vote.
do is advisory.
Right, but
Such as, Vaughn, because no action was taken, our county is left wide open to a lot of damage right now. So I think what he's getting at is until we can have a ordinance complete, that's proper, that's done with an EIR, that's defensible at that point, he's asking, is there a way for this body to send a recommendation forward to the supervisors to put in a moratorium so people slow down the process that's going on, because this is going to be a long process and we have no protections.
So that something is...
I think that if you were to agendize something to say we want to consider making an advisory vote to the board that they shouldn't do nothing, that they should adopt some urgency ordinance, i.e.
Do
moratorium.
we have to call it urgency again?
No,
Yes,
no. If it goes through this board, it's not voted on by the supervisors on an urgency basis.
the purpose of an urgency ordinance is it goes into effect immediately, and it
It can go before the EIR.
can go before the EIR.
Okay.
So anything that happens before an EIR that is by definition on an urgency basis? This is a chicken and the egg thing here, it's in my mind.
Other counties were able to adopt a moratorium or stopping it until they could see what the state was going to do, and they did it by 3 votes.
Yes, you could adopt an ordinance that severely limits or bans cultivation, and because there would be no environmental impact associated with that, you don't need to go through an EIR.
Right.
Our board has decided they want to allow and regulate it, so we need to look at what is the effect of allowing it and how can we incorporate into the regulations mitigations.
Okay, and I understand that's the message that you got on the 16th of February. But I was there on Tuesday, and it seemed to me that there was a different message delivered to you.
Well, no, I don't think so.
And again,
They didn't vote. No one voted there was individual board member statements. But unless a motion is made and passed, there is no direction.
Okay, if we agendize an advisory ordinance, and we pass something that's called an advisory ordinance, it goes to the board under what condition?
It would just simply be I don't know. I don't, the board sort of establishes the direction that they want to take. If you felt that that direction was in error and you wanted to just send an advisory vote that, you know, we disagree with you and we think that you ought to go this direction, I suppose it would just be a memorandum to the board.
Okay, if, on the other hand, the board agendizes the discussion and they get a consensus of a new direction, then it comes then it goes to you to write something that is compliant with this new direction. Then it comes to us for a vote. Then it goes up to them on what basis, urgency or otherwise. It's not an urgency issue anymore, correct?
Well, the permanent ordinance is not an urgency ordinance. And it will go through the normal process for adopting an ordinance. The reason that County Council and I proposed an urgency ordinance to the board is we felt we needed to do something.
I understand that.
And that, you know, need to be done now. We can't wait 2 or 3 months for it. We need to do something right now. The board could have modified that in many different ways. Yes, we need an urgency ordinance, but we don't like what staff has written. We want to put a moratorium on. That's something they could have done. They didn't.
But
The
I
process.
heard County Council asking the board for direction. I can't remember the exact conversation, but it seemed to me that that's what she was doing.
We were both trying to get direction from the board.
Can I ask you a question? Are there other commissioners that have questions about this issue? Because to me, again, I think we're sort of skirting a topic that is not agendized. And perhaps this is a conversation between Peter and Commissioner Tuno.
Well, I have a question.
Okay.
And maybe I'm confused, but aren't we talking about a couple different things here? One would be, is there something that this commission can do to recommend to the board that it impose a moratorium or a freeze, or call it what you want, similar to what was already put before the board, but that alone? In other words, not an accompanying permissive ordinance or anything like that, just a freeze. That's
Yes,
question
you
number
could
one.
do an advisory measure, advisory vote, says, board, we really think you need to do something right away. Here's our reasons why, and we pass that on to the board. It'd be basically an informational document, but it would have the stamp of officialdom of the commission's action as a body.
Okay, and we would have to put that on an agenda
Yes.
in order to do that. Okay, I got that part. My second question is this. I think I've heard two different things, but maybe I just misheard. And that has to do with the necessity for an EIR for a permanent ordinance.
Yes.
And first I thought I heard that any permanent ordinance regarding marijuana cultivation would have to be preceded by an EIR.
Or some environmental
No.
review.
Any ordinance that's
Yeah.
adopted, regardless of what the topic is subject to CEQA.
Right.
Okay, now if you were to have an ordinance, if there were to be an ordinance that said either we're banning cultivation in this county completely, or we're banning everything but pick your limited number of plants for personal use, in other words, effectively banning commercial cultivation, would that require an EIR?
Probably not.
Okay, now, if that's the case, what, if anything, can this commission do in terms of recommending such an ordinance to the board? Can we just do that?
I think
Without an
you could
EIR?
agendize something that says, you know, we think that this is the direction the county should be going.
Okay, you called it an informational document.
Right.
Could it be a draft ordinance?
I think we get into, you're an advisory body, and the board is a legislative body. And their direction takes precedent over what you would like to do. And so we would then be sort of in conflict with the direction from the board, unless they took a vote to say, you know, we think the commission's idea has merit, and we're going to change our mind.
Well, suppose the EIR comes in and the majority of the commissioners said, we understand the board's direction, but we don't agree with it, and we are not going to recommend an ordinance along the lines of that direction. We want something, we think something more restrictive
That's your
is
prerogative.
justified, but we can do that.
You can do that.
Why can't we do the same thing without an EIR if none is required? So I thought that the commission had the ability to initiate and recommend an ordinance really anytime it wanted to.
Well, you can. You can adopt a resolution to initiate an ordinance amendment. I think in this case where the board has already acted on an issue, they've filled the field. They've already said what their policy direction is going to be.
Okay, but it sounds like you're saying that that action trumps our power to take the actions that Kelly is just talked about.
I think if this were a new issue and the board hadn't already addressed it, you have the authority to initiate an ordinance amendment. We want to create something new regarding kite flying. You could do that. But where the board has already stated its policy direction, I think you'd be frankly wasting your time. You could do it. There's nothing that prevents the commission from doing that. And if you think that you could sway the board into changing its policy direction, it may be worthwhile.
Well, just suppose that a majority of the commission, speaking hypothetically, did not agree with the board's direction. And I don't understand the case to be that a majority of the commission then has to approve something that they don't agree with.
Because the board has already given us their direction. I mean,
Why go through us?
why have us?
Well, there could be nuances to the ordinance that you say, okay, we understand the board wants to allow commercial cultivation in the county, but maybe this zone is not appropriate. I think that, I'll be frank, I think that if you just say, we think it should be banned, you'll be wasting your time. If you say, okay, we don't agree, and you could make a statement at the very beginning, we think it should be banned. However, if the board's going to go down this path, here's the changes we would recommend to make it less impactful on the community. I think that would be the purpose. That would be the best use of your time.
I just don't know that we are limited to nuances.
You're not. You're not. And I think you need to, this is a very tricky situation. And I've actually never really been in this before where I see that the commission appears to be opposed to the direction, the majority of the commission opposed to the direction that the board is going. So the question is, what's the best use of your time on this?
So-
Do you want to try to convince the board to change their mind, or do you want to try to make the best thing out of a sow's ear?
Seems to me
I don't know.
It seems to me the simplest way to handle this would be for the board who voted on the February 12th date, or 14th, I don't remember what date, 16th, to ask for a reconsideration.
And that may be sort of the best step to take for you if you're really concerned about this, is that put something on your agenda to ask the board to reconsider. And they could say...
To reconsider what?
To reconsider
reconsider
their
the direction that
February
was given
16th
to
decision.
staff.
Oh,
Yeah.
well, trying to get something done maybe quicker. If we're asking them to reconsider, it's for a reason. Why don't we just look at giving them a package that complies with what we believe should be the case for them to consider?
How would you comply with the
Richard, there's,
We'd have to put something on the agenda. I would, frankly, if there's a conflict between what the board tells me to do and what you want me to do, I'm going to do what the board's going to do.
That's right.
And so I don't want to spend my time preparing an ordinance when the board has said, this is not what we want. I'd rather be working on the general plan. If that's what you want me to do, I will do it.
Okay. If the board were to agendize this reconsideration, how much notice, what's the noticing procedure for that to happen? How soon could they do that?
72 hours?
Okay.
They couldn't take any action on an ordinance. but they could reconsider the direction.
That's
that they're
right,
giving
that's
us.
all.
Yeah.
Now, that would trigger what from you?
Nothing, other than listening and taking notes.
Okay, but then if they voted to reconsider, and they did it along the lines of what I believe the consensus was on Tuesday, hypothetically, that would open the door for us to consider an ordinance along those lines for their consideration, correct?
It would provide direction for me and council to develop a draft ordinance consistent with their direction that then would be sent to you for review.
Okay. Time-wise, that's not... If that were to happen, if that series played out, they make the recommendation, you write the ordinance, we approve it or tweak it or whatever and pass it on to them, and it gets passed by them, the EIR gets put on hold until this is determined, until that moves through the process, because it has the potential to eliminate the EIR. Am I right?
There's a lot of future tripping
There are a lot of
speculation
ifs,
going on here,
but
you know,
yeah.
so what do you guys want to do? Can we like wrap this up? What direction would you like this commission to go? I mean, do you want just to draft a letter to the Board of Supervisors? Is that what your
Well,
pleasure is?
I'm thinking two different things. One is, wouldn't it be a good idea to agendize an item to ask the board to reconsider the freeze, just the freeze, the moratorium? That would be one thing. The second thing would be to agendize an item that would ask the board to reconsider the direction that they gave on February 16th. That would be the two things.
Aren't they related?
They are, but they are not necessarily, don't necessarily go together.
They're two
Okay.
separate actions.
All right.
Two separate actions, and one could be done independently of the other. And I think maybe legislative bodies get in trouble when they try to do too much at one time.
So is there some consensus here?
For the meeting?
I'm having a problem with, it sounds to me what Peter is saying, that he will not draft any kind of an ordinance for the board that is not in keeping with their direction.
All right, he's
That's
not
right.
going to do that.
He's not going to do that.
He's not going to do that.
Yeah, so in other words, we can't really do anything like that.
No, he's,
I think what Commissioner Wooster is suggesting is that you put on your agenda I'm not sure it's necessarily a resolution, but a statement requesting the board to reconsider two items. One is to, essentially adopt an urgency ordinance to put a freeze on cultivation. And the second one would be to reconsider the direction given on the permanent ordinance from February 16th.
Okay. We could agendize that. In the meantime, the board can agendize it on their own.
They could.
To give you direction, eliminating that agenda item from our list.
Certainly.
Okay, so then there's no downside to agendizing it for our 28th meeting.
Yeah, that's correct.
Okay.
all right, so is that, I mean, we're taking action on something that's not.
No, all you're doing
agendized.
is saying you want to
No,
have
all
this
we're
come
doing-
back on
Okay.
future.
No different than when I asked for PD to have a study session.
Okay, so is there consensus that there's, who was, I guess, in favor of having this item agendized for
I am.
28?
I am.
I am as to
And
both.
Okay, and I'm not, so it's
For-
agendized.
for-
It will be. All right, moving on. I guess that's it.
That's all I have.
I would say that, as far as the fifth and the 12th go, and my not being here, not that safety isn't important, but if, just to keep the wheels in motion, if that element comes up to bat, for one of those meetings, then I'd say, I wish you guys would forge ahead without me.
Do what?
Go ahead without me.
Is it possible for her to submit notes to you, Peter, that could be referenced at any point in time during that hearing?
Sure you can.
Sure, yeah.
Because, Vaughn, I'd
Okay.
like to...
We all
have
do
your
that.
notes
Okay.
if
Yeah,
we
if you have
get
anything
to
you want
Peter.
to
All right.
specifically
All right,
address.
just so that we keep the momentum going, and especially knowing that we're going to have a break in June with Peter gone.
Well, the cat's away.
Yeah.
Okay, good.
Okay, with that, we are adjourned. Thank you very much.